Good afternoon, everyone, and thank you for joining the Tour d'Horizon panel. I'd like to start by thanking ICC Canada and YCAP and all of the organizers of this event. I would also be remiss if I didn't thank the wonderful folks at Arbitration Place who've been helping us all week with their virtual platform. We know that this isn't the ideal scenario for a conference and that we would have preferred to see each other face to face to catch up the way we've been able to do in other years, in other normal years, I should say, but due to the pandemic, this is the best we can do. We're going to soldier on, and we hope that you enjoy the panel. My name is Christina Burks. I'm counsel at Borden Ladner Gervais in Montreal, where I've been since 2008, and I practice in commercial arbitration and litigation. I'm very fortunate to be joined today by four wonderful and varied panelists, all of whom are exceptional in their fields, and I'd like to take this chance to introduce them to you. Our first speaker, Jessica Crow, is an international disputes practitioner based in London. Her practice focuses on commercial arbitration, investment treaty disputes, and public international law. She acts as counsel to multinational corporations, states, and state-owned entities across a wide range of industry sectors. Welcome, Jessica, all the way from London. Our next speaker is Sarah Nadeau-Séguin. Sarah is counsel at Ténier Pic in Paris. Sarah specializes in international arbitration, commercial and investment. She has acted as counsel in numerous arbitration proceedings relating to the fields of energy, mining, pharmaceuticals, telecommunications, and construction in both ad hoc and institutional proceedings. Bienvenue, Sarah. Our next speaker is Romeo Rojas. Romeo is a partner at Bennett Jones in Calgary. He acts as counsel in ad hoc, domestic, and international arbitrations, as well as arbitrations under the ICC, LCIA, and ADRIC rules, among others. Romeo also has experience advising both states and investors with respect to disputes under bilateral and multilateral investment treaties. Thank you for joining us, Romeo. Last and not least, we have Tim Robbins, who joins us all the way from Hong Kong. Tim is Chambers Director and Managing Counsel at Arbitration Chambers, a set of leading international arbitrators with offices in Hong Kong, London, and New York. He acts as tribunal secretary in significant commercial disputes and as arbitrator in small and medium-sized commercial arbitrations. Tim is also responsible for the growth and operations of Chambers, supporting its members in developing and managing their practices. I would like to welcome all my co-panelists and thank you for joining me from your respective time zones. I warn all of you that in the interest of time, we will not have the chance to visit all geographic regions, but our goal today is to at least provide you with insight to certain geographical regions. And I think without further ado, I'm going to kickstart this panel. I've been asked to speak about recent developments in the Canadian arbitration landscape. And I think we can all agree it's been a fairly interesting year for Canadian arbitration, not least of which because of a recent decision issued by the Supreme Court of Canada, with which you are all, I'm sure, intimately familiar by now. And I'm, of course, referring to the decision of Uber Technologies versus Heller. So for those of you who have been in a pandemic haze or simply enjoying your summers, which I hope you have, I'm going to briefly go over the facts of the Heller case. Mr. Heller had entered into a series of agreements in order to access Uber's online platform, which contained a series of arbitration clauses requiring that Canadian drivers submit disputes to mediation and then to arbitration, under the auspices of the International Court of Arbitration of the ICC. The seat of the arbitration was Amsterdam, and the filing fee was approximately $15,000. Mr. Heller wanted to institute a class action on behalf of all Uber drivers in Canada, seeking a declaration that they are employees of Uber and therefore entitled to benefits under Ontario's Employment Standards Act. Uber, of course, moved to stay the proceedings in favor of arbitration. The Court of First Instance stayed the proceedings, holding that the validity of the arbitration clause had to be referred to arbitration in accordance with the competence principle. The Court of Appeal, however, disagreed with the Court of First Instance and allowed Heller's appeal, and held that the dispute over the validity of the arbitration clause did not need to be referred to an arbitrator because it found that the arbitration clause itself was unconscionable. It came to that conclusion due to the inequality of the bargaining powers between the parties and the improvident costs of the arbitration. The majority of the Supreme Court agreed with the Court of Appeal and held that the validity of the arbitration agreement should be determined by the court, and thus created a new exception to the rule of referring the question of competence of the arbitrator. The majority held that there was an unequal bargaining power because it was part of an unnegotiated standard form contract or a contract of adhesion. It also held that there was a significant gulf between the parties' sophistication. And lastly, it held that somebody in Heller's position could not be expected to understand the financial and legal implications of such an arbitration clause. The court further held that the arbitration clause was improvident because of the costs, and as a result, the court held that the arbitration clause in question was unconscionable. I should note that there was also a debate about which arbitration statute should apply, with Uber arguing that the International Commercial Arbitration Act should apply, and Heller arguing that the Ontario Arbitration Act should apply. Though the court recognized that there wasn't really a debate as to the international nature of the debate, it held that labor and employment disputes are outside of the purview of the International Commercial Arbitration Act, and therefore held that it was the Arbitration Act that should apply. I think in this case the dissenting reasons are worth going over if very briefly. Justice Brown, in his dissent, agreed with the majority's conclusion that the arbitration clause in question was invalid. However, Justice Brown would not have applied the doctrine of unconscionability and would have rather relied on a denial of access to justice, which of course is contrary to public policy. Justice Cote, on the other hand, disagreed with the majority and would have granted the stay of proceedings in favor of arbitration, though she would have ordered that Uber forward the filing fees to Heller in order to institute the proceedings. So what are the consequences of the Heller decision? I'm going to abstain from giving my personal views on this decision. I think there are people much wiser and more experienced than I who have already given their opinions in, for those of you who haven't read them, numerous articles, also numerous conferences. I would say that the general consensus seems to be that the Heller decision is problematic, particularly because it strays from the competence principle. There are some happy exceptions. I did find one article co-authored by Tina Cicchetti, Elisa King, and Joshua Carton, poetically entitled, "The Supreme Court of Canada Charts a Safe Route Between the Scylla and Charybdis of Hostility to Arbitration and Competence Absolutism." But I'd like to take a look at what has happened since the Heller decision. It will come as no surprise to many of you that following the loss, its loss at the Supreme Court, Heller has now redrafted its arbitration agreement, which it published on August 31st, 2020. I imagine there was the pitter-patter of many an external and in-house counsel's feet as people scurried to rewrite their clients' arbitration clauses, and it comes to no surprise that Uber did the same thing. Uber is now allegedly asking its drivers to sign the new arbitration agreement, and I just want to go over some of the key terms and conditions. So in bold capital letters, the new arbitration agreement provides that if a co-contractant does not opt out of the arbitration provision, they are agreeing to arbitrate and agree to, and here I'm quoting, not to participate in and therefore will not seek or be eligible to recover monetary or other relief in connection with any class action or other collective proceeding. I'd also mention that further down in the arbitration provision, there is actually an explicit clause waiving a party's right to class actions. The arbitration will be under the ADRIC rules of arbitration as opposed to the ICC rules. The seat of arbitration is the province or territory where one resides, and if one resides outside of Canada, the seat of arbitration is Ontario. Arbitration hearings can now be held via phone, email, video conference, or other mediums. With respect to paying for the arbitration filing fee under ADRIC still applies, except, and this is a very important exception, and here again I'm quoting, except that your portion of any initial arbitration filing fees in total will not exceed the amount of the filing fee to start an action in the Superior Court of the territory or province where you reside. In addition, where required by law, Uber will pay the arbitrator's fees as well as all fees and costs unique to arbitration. I should mention that there is also an opt-out clause, and a party has the opportunity within 30 days of having electronically accepted the terms and conditions of opting out of the arbitration agreement. So I think it's fairly clear that what Uber is trying to do in this new arbitration agreement is address some of the concerns expressed by the court. Uber, in fact, released a statement saying that with the updated arbitration clause, dispute resolution is now more accessible to drivers. So it's clear that that's their goal. It does not, of course, change the fact that we're still dealing with a contract of adhesion, and some may wonder if a driver who wants to use Uber's platform is really going to, read through the arbitration agreement from A to Z, and whether they're even going to get to the opt-out clause. There's also concern, of course, about the impact that this new arbitration agreement will have on the pending class action, which was instituted in 2017, and of course, which was the genesis of the Heller decision. I found 4 cases that have cited Heller, though only one deals with the arbitration provision in particular, because the others dealt more with the court's interpretation of unconscionability. In Re Aldred Estate, a decision issued on August 17, 2017 by the Court of Queen's Bench of Alberta, the court was faced with a variation application which in part sought a determination that the arbitration provision was invalid, as well as certain other clauses in the settlement agreement as a whole. And the applicant claimed that this was because they were unconscionable, grossly unfair, and improvident. So we're starting to see a little bit some of the same language that we saw in Heller. The court thus had to decide whether it was going to hear the dispute or refer it to arbitration. The party seeking a stay of proceedings did acknowledge Heller, although they argued that in their case there was no issue of inequality of bargaining powers and no issue of unconscionability. The court agreed with that argument and concluded that the stay should be granted, in part noting that the applicant had had the benefit of legal counsel before signing the agreement. So I think that that's an important distinction to make. The court also noted that though the arbitration clause may be inapplicable without necessarily being invalid, that is for the arbitrator to decide. And here I'm quoting the court when it said, "This is consistent with case law and legislation affirming the importance of holding parties to their agreement to arbitrate, except in unusual circumstances." So I think it's clear that the Heller decision will have a ripple effect for some time to come, and that we'll be hearing more about that case in the future. The second case I'd like to discuss is another case which I think will create a ripple effect. This one is, if you will, a little bit more friendly to arbitration. The case is International Air Transport Association versus Instrabel. The majority of the Supreme Court issued its decision in December of 2019. However, interestingly enough, the dissent, which was issued by Justice Cote, was only released in May of this year. So again, I'm going to briefly go over the facts. This case is essentially one of the enforceability of arbitral awards. Instrabel was a Dutch company that had entered into certain contracts with a variety of Iraqi entities for the supply of military equipment. And then in 1990, with the attack on Kuwait, the US Security Council imposed a series of embargoes for all goods going into or coming out of Iraq. Instrabel, as a result, instituted arbitral proceedings again at the ICC against Iraq for non-performance, and 2 arbitral awards were in fact awarded in favor of Instrabel. The first one in 1996 and the second one in 2003. The 2003 award ordered Iraq to pay Instrabel $32 million US with interest. By 2013, Iraq still hadn't paid the award, and so Instrabel instituted proceedings before the Superior Court of Quebec, asking that it be allowed to seize money at the International Air Transport Association, which is headquartered in Montreal, claiming that IATA had funds from Iraq. So IATA does collect fees from airlines located in different countries for the right to fly over and into those countries, and one of those countries is in fact Iraq. But otherwise, what's interesting about this case is that IATA was not remotely involved in the dispute between Instrabel and Iraq. In July 2013, fearing that the payment of the arbitration award was perhaps in jeopardy, Instrabel then obtained a writ of seizure before judgment from the Superior Court for amounts being held by IATA on behalf of the Iraqi Civil Aviation Authority. The ICCAA, as I'll call it now, and IATA moved to have that seizure quashed. And in 2015, Iraq amended its motion, claiming that Quebec courts lacked jurisdiction because, in fact, the money was being held in a bank account in Switzerland, not in Quebec. So here, the Court of First Instance decided that it did not, in fact, have jurisdiction to order the seizure before judgment because the money was outside of Quebec at the time of the seizure. And it did grant Iraq's motion to quash. In addition, it held that because the money held by IATA on behalf of Iraq was not, strictly speaking, a debt, it rather held that it was a mandate under Quebec civil law. Under Quebec law, it could not be seized. The Court of Appeal overturned the Court of First Instance's decision. It held that the money being held by IATA was in fact a debt, and that was whether it was considered a mandate or any other type of contract, and could thus be seized under Quebec law. In addition, regardless of where the money was physically being held, the Court of Appeal felt that the debt legally existed at IATA's offices in Montreal. The court rendered, as I said, its decision on the bench in December 2019 and dismissed the appeal by IATA and Iraq, simply stating substantially for the reasons of the Court of Appeal. I think it's fair to say that the court's decision can be read as a sympathetic decision for the difficulties faced by parties who are seeking to enforce awards, and it may draw attempts from parties seeking to enforce awards even though they are not in Canada. So I think here what we'll be looking for in the future is to see whether there are an elevated number of applications to enforce awards in Canada regardless of where the parties are located. So I think 2 very interesting decisions coming out of the Supreme Court this year, and I think we'll certainly be hearing more about each of those decisions in the future. So I think with that, I will pass the baton on to my co-panelist, Jessica, who's the next speaker. Jessica has been tasked with speaking about recent developments in England and the United States. So thank you, Jessica.
Thank you, Christina. I will be providing the update from the UK and the US today. Due to time constraints, I've had to be selective, and I've decided to focus on two major developments in arbitration case law that have made their way to the Supreme Court in each jurisdiction. The first sees the US Supreme Court ruling on the applicability of domestic state doctrines that permit the enforcement of arbitration agreements by non-signatories under the New York Convention for the first time in many years. And the second sees the UK Court of Appeal laying down guidance on a long unresolved issue in English arbitration law, namely the applicable law to the arbitration agreement in the absence of an express choice. So I'm going to start with the United States. The 2019-2020 term saw only one arbitration case on the Supreme Court docket, and that was GE Energy Power Conversion France versus Outokumpu Stainless USA. In this case, as I just said, the court heard an unresolved procedural question in international arbitration in the United States, namely the question of whether the New York Convention permits a non-signatory in international arbitration in an international arbitration agreement to compel arbitration based on a domestic state doctrine of equitable estoppel or another underlying state contract law principle. And in a much anticipated decision, the court evaluated the terms of the convention and held that the answer is in fact yes, resolving a circuit split over whether the convention permits a non-party to compel international arbitration on the basis of a state court theory. So I'm just going to take a step back and walk through the facts quite quickly. The case arose in the context of a construction dispute. ThyssenKrupp entered into 3 contracts with FL Industries for the construction of cold rolling mills in its steel manufacturing plant in Alabama. The contracts provided for arbitration in Dusseldorf under German law. GE Energy, a French company, built and installed motors for these mills as FL Industries subcontractor. Later, when the motors allegedly failed, Outokumpu brought a suit in Alabama State Court on a theory of tort and warranty, at which point GE applied to remove the case and filed a motion to compel arbitration. The problem was that GE was a subcontractor and didn't have a direct contractual relationship with Outokumpu. So what GE did is based its motion to compel on a domestic doctrine of equitable estoppel. And this doctrine states that a signatory to a written agreement will be equitably estopped from blocking a non-signatory from compelling arbitration when its claims against the non-signatory must rely upon the terms of the same agreement. GE prevailed at the district court. However, the 11th Circuit Court of Appeals reversed. And interestingly, the Court of Appeal focused on whether there was a sufficient agreement in writing for the purpose of the New York Convention. Looking in particular to Article 2, the court interpreted the convention as imposing a requirement that parties actually sign an agreement to arbitrate the disputes, and held that GE could not rely on state law equitable estoppel doctrines to enforce the arbitration agreement because they hadn't signed anything. The case made its way to the Supreme Court, and in a much anticipated decision, a unanimous decision authored by Justice Clarence Thomas that came up this summer, the court reversed the 11th Circuit's ruling on narrow terms, finding that the convention does not preclude non-signatories from enforcing arbitration agreements based on the application of domestic equitable estoppel doctrines, but didn't actually go so far as to determine whether the equitable estoppel doctrine applied in this case. It remanded that question back to the 11th Circuit. The court's analysis started by addressing the Federal Arbitration Act, which itself permits the application of state law doctrines to the enforcement of arbitration agreements. And it then also turned to the New York Convention, noting that the convention actually itself almost is entirely focused on the enforcement of arbitral awards, and it contains only 3 provisions, each a sentence long, on arbitration agreements. So examining Article 2 of the New York Convention in particular, it found that the convention is just simply silent on the issue of non-signatory enforcement, and in this case, the silence was dispositive. It held that the convention doesn't prevent the application of domestic laws that are more generous in enforcing arbitration agreements, and that domestic law could be used to fill in any gaps left in the New York Convention. However, as I said, the court declined to decide whether the equitable estoppel principles should actually allow the non-signatory to compel arbitration in this case, and instead remanded it back to the 11th Circuit, which will pave the way for the federal court to decide whether GE can enforce the arbitration clause under the equitable estoppel principles and which body of law will govern that determination. Finally, it's worth noting that Justice Sotomayor authored a concurrence cautioning that while equitable estoppel would be available in the instant case, any applicable domestic doctrines must be rooted in the principle of the consent to arbitrate, and there have been a lot of commentary that has arisen as a result of this concurrence. What's interesting about this case is that while it aligns the regime for enforcement of international arbitration agreements under the convention with the regime for enforcement of domestic arbitrations under the Federal Arbitration Act, it leaves in its wake a litany of new legal issues posed by non-signatory enforcement. And this is going to fall to the lower courts to navigate these difficult questions, which include questions of choice of law, the availability of third-party signatory doctrines under the applicable law, and of course, issues of consent. And this is going to vary widely state to state. So it's not necessarily promoting a uniformity of interpretation outside of the narrow point. Turning to the issue of consent versus coercion, this is something that much has been made of in the commentary following the decision. I mean, in this case, coercion was likely not an issue because the party being compelled to arbitrate, Outokumpu, had actually signed the arbitration clause, and the contract in this particular case indicated that non-signatories like GE France were parties to the contract, even though they never signed it. But had the situation been reversed and Outokumpu had attempted to use the state theory to try to compel arbitration against GE, one could see how a circumstance like that could potentially violate the Federal Arbitration Act's consent principle. Further, if only GE can compel arbitration, you can see how a tactical asymmetry emerges, and that one party has the opportunity to forum shop, and in the inverse, the other party may be faced with a circumstance where its right to a jury trial is violated. Some commentators have noted that Justice Sotomayor's concurrence may have been out of concern for these issues, particularly as they apply to individuals, and this is something we've just seen in Christina's presentation in the Uber case. The justice has advocated that the lower courts be very careful in determining on a case-by-case basis that whether or not applying a domestic non-signatory theory violates the Federal Arbitration Act's consent principle. So in a nutshell, the Supreme Court's decision clarifies that in general, the New York Convention will set a floor and not a ceiling on arbitration agreement enforcement for non-signatories, and thereby broadens the scope of who can enforce in international arbitration. But it doesn't actually go so far as to make a determination on those state court theories. So I'm going to now turn to the UK. And as I explained earlier, there's a very important case in this jurisdiction that has made its way through the courts. And this is the case of Enka versus Chubb. And earlier this year, the Court of Appeal laid down some guidance on the proper law of arbitration agreements. However, it remains to be seen whether the Supreme Court will agree. This case has, of course, garnered significant interest and will become a reference on this point once the Supreme Court has handed down its ruling. I'm going to take a step back again and go through the key facts quickly. The appellant in this case before the English court was Enka. This is a case, it was another construction case. Enka is a Turkish construction company who in 2012 became a subcontractor in the construction of a power plant in Russia, entering into a contract with the general contractor that later assigned its rights to a company called Unipro. The contract contained an arbitration agreement providing for all disputes to be resolved by ICC arbitration seated in London. However, the arbitration agreement did not contain an express choice of governing law. There was also no express choice of governing law for the contract. There was a defined term entitled applicable law, which referred to Russian law and regulation, and the Russian Civil Code was referenced in various provisions of the contract. However, there was no boilerplate governing law clause that the parties could refer to. In 2016, there was a fire in the plant, and Unipro claimed and received a payout from its insurer, Chubb, in respect of damage caused. Chubb later commenced proceedings in the Moscow court against Enka and 10 of the defendants for recovery of the sums paid. Enka, in turn, sought an anti-suit injunction from the commercial court in London on the basis that the Russian proceedings violated the arbitration agreement, which Enka argued was governed by English law. Chubb resisted the anti-suit injunction on the ground that the arbitration agreement and the contract as a whole were governed by Russian law, pursuant to which the Russian proceedings actually fell outside of the scope agreement because they were tort claims. In the first instance, Chubb prevailed. The judge refused to exercise jurisdiction to grant anti-suit relief, holding that the a priori jurisdiction lay with the arbitral tribunal, and because there was no arbitral tribunal constituted or an arbitration afoot, it declined to exercise jurisdiction on forum nonconvenience grounds, a point of law that was actually not raised by the parties. Applying this approach, he considered that the Moscow court was in fact the appropriate forum and declined to decide whether the proceedings were in breach. More interestingly, in another point in the ruling, you see the beginning of a debate on the significance of deceit in the absence of an express choice in order to determine the law governing an arbitration agreement. In this case, the judge reviewed the authorities, including the three-part conflict of law test, otherwise known as the Sul America test, and held that the construction of the proper law of the arbitration agreement in the absence of an express choice is a matter of contractual interpretation, but that the choice of the seat alone is not an express or implied choice of the law of the arbitration agreement, really finding that the choice of a seat is much more of an indication of a preference for a geographic location of the hearing, for example. And I quote, he said that it indicates a joint personal preference to come to London rather than, say, Paris, Geneva, New York, or Singapore, but that it would not even be arguable that it conveyed or implied a choice of English law as a governing law for the arbitration agreement. ENCA appealed the case, and the English Court of Appeal overturned the first instance judgment. And the Court of Appeal found that the High Court had been wrong in principle by failing to decide whether the Moscow claim was in breach of the arbitration agreement. The English Court, the Court of Appeal found that the English Court, as the court of the seat, is necessarily the appropriate forum to grant anti-suit injunctions, and the questions of forum convenience were of no relevance. And it referred to two essential principles in coming to this conclusion. Both principles were articulated by Lord Hoffman in the famous West Tankers case. The first being that the choice of the seat of the arbitration is an agreement by the parties to submit to the jurisdictions of the court in that seat, and the exercise of such powers, and that the grant of an anti-suit injunction to restrain a breach or threaten breach of an arbitration agreement is necessarily an exercise of such powers. So the takeaway being that the choice of the seat is a legal concept which determines the curial law, and it is distinct from the geographical venue in which the hearings take place. And the court found that this principle was supported in a number of English law authorities, logic, commercial sense, and was borne out of evidence by business practice. And second, and more interestingly, the controversial point on the correct approach to determining the proper law of the arbitration agreement, Lord Popplewell indicated that the time had come to seek to impose some order and clarity on this area of the law, in particular on the relative significance attached to the main contract law on the one hand, and the law of the curial law of the arbitration on the other hand, in determining what the correct law of the arbitration agreement should be. The court undertook a thorough review of the relevant authorities, including the Sul America test, and clarified what the correct approach should be in light of what it termed the inconsistent way that the conflict rules had been applied by judges in the past. And he concluded that where there is an express choice of law of the contract, it will be a matter of construction of the whole contract, including the arbitration agreement. However, in all other cases, the general rule should be that the law of the arbitration agreement is that of the curial law, i.e. the law of the seat, as a matter of implied choice, unless there are very powerful reasons to the contrary. And he noted that there was no principled basis for treating the main contract law as a significant source of guidance over and above this. And in so ruling, he really emphasized the importance of the doctrine of separability as articulated in Section 7 of the Arbitration Act and in the House of Lords case, Fiona Trust versus Privilove. And in addition, that it made good commercial sense. He noted that it was inherently unlikely that, and contrary to commercial sense, that business people would apply two different systems of law for their arbitration package. Applying these principles to the case, the Court of Appeal held that even though the main contract law was Russian in this case, the law of the arbitration agreement was English and granted the anti-suit relief on the terms sought. So the case has now been appealed and argued before the Supreme Court in July 2020, and the decision is pending. In the meantime, there's been quite a bit of commentary on the Court of Appeal's judgment. Some have welcomed the judgment and pointed to how it demonstrates the readiness of the English court to provide support to arbitration seated in the UK and emphasizes the attractiveness of London as an arbitral seat. The court underscored an important aspect of party autonomy. The right to choose the governing law and the seat of arbitration is done according to what parties will consider serve their best interests. And it also endorsed the view that parties choose particular arbitral seats because of their legal infrastructure, the arbitration law and track record for enforcing agreements to arbitrate. On the other hand, critics have argued that the court overstated the separability doctrine to justify its conclusions, instead of using it as a point of departure for to undertake the analysis of the proper law of the arbitration agreement in the context of the main contract. and that it potentially placed too much weight on the presumption that contractors would not be expected to choose two different systems of law to apply to their arbitration package. These critics have argued that in reality, perhaps it's unlikely that all such that the intricacies of the various laws that apply to the arbitration package are always explained and understood in such detail. And perhaps it's more realistic to say that contractors should not be taken to have intended to have different systems of law applying to their entire relationship. So it will be interesting to see where the Supreme Court falls on this issue. The case is certainly likely to become the leading English law authority on the applicable principles relating to the approach to determining the proper law of the arbitration agreement. And in the meantime, as a drafting note, it may be prudent to make a clear and express choice of law, not only in the main contract, but also in the arbitration agreement. So that concludes my presentation. Thank you very much. I'm going to turn it back to Christina.
Thank you very much, Jessica. Two interesting cases indeed. It will be interesting to see what the US lower courts do with that decision. But your UK decision is a perfect segue into some of the next presentations, which I think will also be dealing with applicable law. So with that, I'm going to hand it over to Sarah. Sarah is going to be dealing with continental Europe.
Thanks, Christina. Good afternoon, everyone. My name is Sarah Nadeau-Séguin, and I'm counsel with Tenue-Peak in Paris. And I have, as Christina said, the great honor, but also the great challenge of trying to walk you through some of the most interesting developments in international arbitration in Europe over the past few months in just under 15 minutes. It would, of course, be impossible to cover all of the interesting developments in the 27 countries that form the EU in the time that I have. So I have selected some of the most interesting and I think consequential developments that are non-COVID related. And you will have the references displayed on the slides that you will see on the screen. So the first development takes us to Spain. On the 15th of June 2020, the first chamber of the Constitutional Court handed down a judgment declaring the nullity of several decisions by the civil and the criminal chamber of the Madrid High Court, finding that they contained an overly extensive and unjustified interpretation of public policy. The facts are not particularly relevant. Basically, the case concerned a dispute between a landlord and a tenant over the lease agreement that they had signed. An arbitration award was rendered, pursuant to which the tenants were evicted from their property and required to pay rent. The tenants began proceedings with the High Court of Justice of Madrid to annul the award on the basis that the clause submitting any dispute to arbitration was abusive and contrary to public policy. However, before a decision was rendered, the parties reached an agreement and applied to the High Court of Justice to terminate the annulment proceedings. The court, however, refused to terminate the proceedings, finding that the parties could not withdraw from the action to annul the award because there was a general interest in deciding whether or not that award was contrary to public order. The parties then applied to the Constitutional Court of Spain, arguing that the decision forcing them to continue with the annulment proceedings violated their right to effective judicial protection under the Spanish Constitution. The Spanish Constitutional Court agreed. It warned that although it's not clearly defined, the concept of public order and public policy could not be used as an excuse to review the merits of the award. The court stressed that annulment proceedings must be limited to an external oversight of the validity of the award without reviewing the merits reached by the arbitrators. And so, although the specific issue before the court in that case was whether parties have freedom to withdraw from an action on annulment, this decision more generally confirms that setting aside proceedings in Spain will only involve a limited level of external control, and that public policy and public order will be construed somewhat restrictively. So this is a welcome development for arbitration law in Spain. By curbing judicial review of arbitral awards, it confirmed Spain as an arbitration-friendly jurisdiction. There had been similar developments years ago in France, and the Paris Court of Appeal intervened to limit the use of the notion of public policy in the context of setting aside proceedings. And that chapter has now definitely been closed. So it's great to see that Spain is moving in the same direction. which is a great segue into the next development that I wanted to talk about. And this case takes us to France. It's the Domo case, which is a case rendered in February of 2020 by the International Chamber of the Paris Court of Appeal. This is its very first decision ever on an application to set award an international arbitral award seated in Paris. For context, the International Chamber of Paris was created in February of 2018 in order to make France more attractive as a forum to litigate international business disputes. So the Chamber hears disputes relating to international commercial contracts in English, and since January of 2019, it also hears all proceedings for setting aside of arbitral awards rendered in international arbitration seated in Paris. The Domo case concerned a dispute between Domo and several other Brazilian companies that were bound by a joint operating agreement. Domo brought LCIA proceedings against these companies, and because they were split proceedings, the tribunal rendered a total of 5 awards. Domo then sought to have all of these 5 awards set aside, alleging that the tribunal lacked impartiality and independence. Domo claimed that it had discovered during the arbitration that the arbitrator appointed by the respondent had failed to reveal links between him and one of the respondents. Specifically, what happened is that in the course of arbitration, one of the respondent entities, Bara, had added a new counsel to its team, which then prompted the arbitrator appointed by respondent to disclose that he had worked for 2 years as a senior international counsel in a law firm in Saudi Arabia, and that law firm had an alliance with Blake's, which had in the past acted for 2 funds that had a majority shareholding in Bara. Domo tried to challenge the arbitrator before the LCIA, but the LCIA rejected the challenge. Domo then moved to have the awards annulled. The court refused to set aside the award and rendered a decision that has several interesting layers to it. First, the court ruled that the arbitrator should have disclosed his involvement with Blake's because they were not sufficiently notorious. The general rule under French law is that arbitrators are required to disclose any circumstances that are likely to affect their independence or their impartiality before accepting their mission as well as throughout their mission. But there is an exception to that rule, the so-called notoriété exception, i.e. facts that are sufficiently notorious or that are sufficiently known and easily accessible do not need to be specifically disclosed. So the question before the court was therefore whether the arbitrator's prior relationship with Blake's was sufficiently notorious that it did not need to be disclosed. And the court found that it wasn't the case because the information wasn't easily accessible. It took various manipulations and various clicks on the arbitrator's websites. You had to cross-reference various pages of his CV to get to this information. And so the court concluded that it had to be specifically disclosed. But in the second part of its decision, the court reaffirmed that every failure to disclose should not, in itself, always lead to setting aside an award. The information not disclosed must be such as to provoke a reasonable doubt in the mind of the parties as to the impartiality and independence of the arbitrator, considering the specific facts in the case. And so the court noted that the ties between the arbitrator and the respondent entity, Bara, were indirect. They were through another firm. They had ceased over 2 years before the start of the arbitration. And so in these circumstances, the court concluded that these facts did not establish a reasonable doubt about the independence and impartiality of the arbitrator. So in sum, this decision is an important reminder of the extent of an arbitrator's duty to disclose, as well as an important confirmation that any failure to disclose will not automatically lead to setting aside the award. This decision also has symbolic significance because it's the first decision rendered by the International Chamber of the Paris Court of Appeal in setting aside proceedings. And if it gives any insight as to how the court will exercise its role going forward, we can conclude that the International Chamber has taken quite a pragmatic approach to the issue of arbitrator disclosure. While we are still in France, we can move on to the third development, which also comes out of the Paris Court of Appeal, and which will tie in nicely with Jessica's presentation on UK law. On the 23rd of June 2020, the Paris Court of Appeal dismissed a request to annul an international arbitration award in the case of Kout Food and Kebabji. And this is an important development because the English Court of Appeal had reached a completely different result just months prior and had granted an application not to enforce the award. Very briefly, the case concerned a franchise development agreement, an FDA, that had been entered into by Kebabji and an entity known as AHFC. The agreement contained an arbitration clause providing for ICC arbitration with the seat in Paris, and the agreement generally called for the application of English law, but there was no express reference in the arbitration clause made to the law governing the arbitration agreement. There was a corporate restructuring following which the entity known as AHFC became a subsidiary of the group Kout Food Group, which led Kebabji to initiate proceedings in March 2015, not against AHFC, with which it had signed a contract, but with Kout. In September of 2011, the arbitral award found that Kout, who was a non-signatory to the arbitration clause, had become a party to the franchise agreement and to the arbitration clause it contained as a matter of French law, and found that Kout had breached the FDA and ordered it to pay damages to repair its breaches of the franchise agreement. So Kout immediately moved to have the award annulled before the Paris Court of Appeal. Less than 2 weeks later, Kebabji issued proceedings in London seeking to enforce the award, to which Kout replied by a petition for an order that recognition and enforcement of the award be refused. In January of 2020, the English Court of Appeal granted Kout's application not to enforce the award. It found that the parties had expressly chosen English law to govern the arbitration agreement based on the franchise agreement's governing law clause, and held that this conclusion was not disturbed by their choice of Paris as the seat of arbitration. But a few months later, in June of 2020, the Paris Court of Appeal dismissed Kout's annulment request. The Paris Court of Appeal held that the tribunal had correctly applied French law to determine whether or not it had jurisdiction over Kout as a non-signatory. The court also ruled that there was no express choice of English law to govern the arbitration clause, and that in the absence of this express choice, the proper law of the arbitration agreement was French law, as that was the law of the arbitral seat. When it came to the non-signatory question, the court found that the arbitration agreement extended to Kout. In order to reach this conclusion, the court conducted a detailed factual inquiry looking at indications of implied consent, with a particular focus on indications of participation in the performance and the conclusion of the contract, as well as knowledge of the existence and scope of the arbitration clause. And after reviewing the relevant facts, the court found that Kout had been involved in the performance of the franchise agreement, and therefore that the arbitration clause that the franchise agreement contained extended to Kout. So it may be surprising to be confronted with such contradicting decisions coming out of the courts of England and the French courts, but it's worth noting that it's not the first time this has happened. Roughly 10 years ago, in the Dalla case, the UK Supreme Court denied enforcement of an award against the government of Pakistan that was also raising a non-signatory question, while the Paris Court of Appeal reached the very opposite conclusion, rejected the Pakistani government's jurisdictional objection, and confirmed the arbitral tribunal's award. More generally, the Kebabji case reminds us of the issues that can arise when parties choose an arbitral seat that is different from the governing law of the contract, but is also a good reminder that French courts and English courts take a very different approach when it comes to determining the proper law of the arbitration agreement. As Jessica very clearly explained, for English courts, the arbitration agreement must be governed by a domestic system of law. And so the approach really is a conflict of law approach, which starts by construing the agreement itself to determine whether or not the parties have made an express choice. Whereas the French courts have a completely different approach. They apply what is known under French law as a règle matérielle, a material rule, according to which the existence and the validity of an arbitration agreement must be assessed by reference to the common will of the parties without the need to refer to a particular system of national law. So very different approaches, perhaps another reminder to be as precise as possible when drafting the arbitration clauses. Which takes me, in the time that I have left, to the last development I wanted to touch upon today, the signing in May of 2020 of the termination agreement. This is an agreement that was signed by the majority of EU member states in order to terminate all bilateral investment treaties that have been concluded between two member states of the EU. The treaty was signed by almost all member states except Austria, Finland, Sweden, and Ireland. And it has been described as the latest consequence of the Achmea decision. This is the decision that the Court of Justice of the European Union rendered in the Slovak Republic v. Achmea case in March of 2018. And in that decision, the court had ruled that the investor state provision contained in the Slovakia-Netherlands BIT was incompatible with EU law. I mean, really, one could dedicate an entire presentation to this termination agreement, and I can't do it justice in the time that I have left. But the main takeaways is that there are three categories of arbitration in the termination and the impact in the termination agreement, and the impact that the termination agreement has on these arbitration agreement is dependent on the date at which the arbitration proceedings were launched. So for arbitration proceedings that were concluded before the 6th of March 2018, which is the date of the Achmea decision, the termination agreement is without prejudice to their legal effect. The situation is, however, very different for arbitrations that are either pending or new. So pending at the time the Achmea decision was rendered, or new, so they were initiated after the Achmea decision. For pending arbitrations, while the agreement sets up a transitional regime to deal with these pending intra-EU disputes, the clear stance is to either get them quashed, discontinued, or settled altogether. For new arbitrations, the termination agreement provides that the arbitration clauses in the intra-EU BITs will no longer serve as a basis for new arbitration proceedings, so that door is closed. And the termination agreement even purports to terminate the so-called sunset clauses in these intra-EU BITs. So these are clauses that would have otherwise extended the validity of the relevant BIT for a further period after its termination in relation to investments made prior to the termination. So very briefly, we cannot understate the importance of this development for investment arbitration in Europe. There are, however, a number of gaps, gray areas, and legal questions that are posed by the text of this agreement. And so I think it's safe to say that the road forward has not yet been clearly defined for intra-EU arbitration, and we will have to watch the space to get a clearer picture of what lies ahead in the coming months. This is the end of my presentation, and I will hand it over back to Christina. Thank you very much.
Thank you very much, Sarah, for a very efficient presentation on all of continental Europe, which, as you said, is no easy task. And I'm going to keep moving along because our next speaker, Romeo Rojas, has no less of a difficult task, as he will be presenting recent developments that have taken place in Latin America and I think the Middle East as well. So good luck with that, Romeo. Thank you.
Thanks, Christina. I'm indeed going to be talking about some developments in Latin America and the Middle East over the past year. Given the number of jurisdictions there are to cover, I propose to just focus on three topics. The first is an interesting case out of Brazil on competence. It ties into your earlier discussion of the Uber case. The second is an economic sector and case to watch out of Mexico. And lastly, a decision out of the UAE with respect to enforcement of arbitration awards in that jurisdiction. So the first case I want to talk about is, and pardon my pronunciation, De Oliveira versus Hospital Meridional out of the Espírito Santo Court of Appeal in Brazil, which was issued late last year. The case is of interest because the court there had to consider exceptions to the competence principle. So similar discussion to the issues faced in Uber, Dell, and TELUS that we've seen in Canada, although perhaps a bit more straightforward facts in this case. For the sake of time, I'll simplify the facts a little bit. The dispute in question arose out of an investment that a group of doctors made in a hospital in Brazil, the Hospital Meridional in the title of this case. And those doctors jointly invested in this hospital through which they were going to provide their medical services. And they entered into a shareholders agreement with respect to that investment, which among other things granted them exclusive rights to provide services in their areas of specialty in that hospital. And each doctor leased his or her office space from the hospital. So importantly, the shareholders agreement did not contain an arbitration clause. And after a number of years, there appears to have been some friction between the investors. It caused them to form a majority group and a minority group. And the majority group of investors attempted to force out this minority group by trying to compel them to dispose of their shares, exercising their minority control over the hospital to refuse to renew their lease agreements for their practices, and attempting to dilute their interest through increasing the share capital. So this led the minority shareholders to file a series of lawsuits in the Brazilian courts because there wasn't an arbitration clause in question at the time. And the majority investors won. And this is where the story gets interesting and where arbitration gets involved, because what happened was, not being happy with the outcome of the litigation, the majority shareholders amended the hospital's bylaws to provide that shareholder disputes had to be resolved by arbitration. They then commenced an arbitration against the minority shareholders, claiming that their court actions were abusive. So instead of challenging the validity of the arbitration agreement in the arbitration that had been commenced, the minority shareholders brought an application in the Brazilian court of first instance, seeking to stay the arbitration on the basis that there hadn't been a consent. The court of first instance, strictly applying the competence principle, refused to grant the stay, basically finding that the arbitral tribunal had jurisdiction to rule on the validity of the arbitration agreement in the first instance. The minority investors appealed, and on appeal, the Espírito Santo Court of Appeal considered the evidence before it that there was an amendment to the hospital bylaws to add this arbitration clause, and that amendment had not been done in accordance with Brazilian corporate law. And it also considered that the clause had been inserted into the shareholders agreement or the bylaws after the events in dispute had arisen, and after, in fact, the court had actually ruled on the dispute. Therefore found on an interim basis that there wasn't a valid consent to arbitrate. So while the Court of Appeal acknowledged the importance of the competence principle in Brazilian arbitration law, it found that the principle couldn't be absolute and that the court had to retain jurisdiction to stay in arbitration when the arbitration agreement was manifestly illegal. And it therefore granted a stay of the arbitration. So in granting the stay, one of the things that the court said it had in mind was that allowing an arbitration to proceed and allowing the arbitrators to determine jurisdiction in a scenario where the arbitration clause was manifestly illegal, it would only just aggravate the damage that was caused to the minority shareholders through the conduct of the majority shareholders. So that was a fundamental ground of this decision, is that for efficiency and fairness to the people who were being subjected to this illegal arbitration clause, it didn't make sense to strictly follow the competence rule. It'll be interesting to see how this is viewed, whether this kind of decision is showing Brazil to be arbitration friendly or not arbitration friendly. And I'll leave it for discussion whether finding an exception or an exemption from the competence principle in these circumstances was the right approach. The second area I want to discuss is arbitration in Mexico generally, and in particular in the energy sector. Mexico is going to be a very interesting jurisdiction to watch over the coming years, both in the commercial arbitration field and the investor state arbitration field. So by way of background, why is the energy sector very interesting in Mexico right now? Well, prior to 2014, all the elements of Mexico's petroleum supply chain were controlled by a state-owned entity, Pemex, while all the elements of Mexico's electricity supply chain were controlled by Mexico's Federal Electricity Commission, known by its abbreviation in Spanish, the CFE. But in 2014, Mexico amended its laws to reform the energy sector. And the 2014 reforms allowed private sector entities to participate to a greater extent in the petroleum and electricity supply chains. And it created particular opportunities for the private sector in pipeline development and in green energy and renewable energy generation. So these reforms led to billions of dollars of private sector investment. However, the liberalization was not all smooth sailing. Mexico and international media have reported on a number of arbitrations involving state-owned entities and private sector investors related to investment projects in these two sectors. In the electrical sector in particular, as I said, most private sector investment has been in green and renewable generation facilities. And these investments have come under increasing pressure from government measures since the change of government in Mexico in 2018, which appears to have a different approach to the liberalization of these industries. So what we've seen in the electricity sector is late last year, Mexico proposed changes to its carbon credit scheme that had the potential to dramatically reduce the value of these credits. Those credits are an important source of income for renewable generators and important to their competitiveness in the market. In addition, there were attempts to significantly increase the tariffs that these renewable companies pay to transmit their energy on state-owned distribution networks. And finally, with the emergence of COVID in Mexico, Mexico introduced a number of regulatory changes that would limit the abilities of renewable companies to access the grid at all. And they were citing the need to protect network stability in the face of reduced power demand during the pandemic. Thus far, the measures in the electricity sector appear to have been principally challenged in the Mexican courts. So what we see is a sector that's very much in flux. And anytime you have that situation, of course, there's a potential for disputes and a potential for interesting cases to come out of that flux. I'd like to give you an example of a specific types of disputes and issues that may arise from this situation. And I'm going to do so by way of a case that was made public in June of this year that arose from the construction of the Chicoacan 2 power station in the state of Chiapas in southern Mexico. Now, this dispute doesn't appear to be related to the liberalization or the policy issues that I discussed before. It's more purely a commercial construction dispute that arose from delays to the construction of this power generation facility. How the dispute arose is the CFE had awarded a contract to construct this facility to a consortium of Mexican and foreign construction companies. And after the construction started, the progress was blocked when various local groups and unions prevented the construction consortium from accessing the site. The reason for that, that blockade, if you will, was that these groups alleged that they had been made certain promises by the state with respect to development of this land, and that had not been honored. So after these delays had accrued, the consortium eventually decided that they couldn't complete this construction. They terminated the contract, and they commenced arbitration proceedings against the CFE in the LCIA pursuant to the arbitration clause in their agreement. I'm not going to get into the legal arguments that arose in the dispute, but the tribunal eventually found in the consortium's favor, and they issued an award in the amount of approximately $200 million US. Now, what's interesting is not so much the arbitration itself, but what happened after the award was issued. And this is why Mexico is going to be an interesting jurisdiction to watch. The first, what's interesting is how quickly the award became public knowledge. The existence of the award was published in Mexican media within days of the award being issued, as were significant details about the findings in the award itself. The second interesting factor was the legal response of the CFE, who had this award issued against it. Rather than applying to set aside the award in the first instance, what this state-owned entity did was apply to the Mexican courts for an injunction prohibiting the successful consortium from applying to the Mexican courts to enforce the award. Now, this application, according to the Mexican media reports, appears to have been rejected by the Mexican courts, but it appears that the possibility for a set-aside application remains outstanding, so it remains to be seen whether that is done. The third interesting element was the consortium's response. They appear to be attempting to avoid the Mexican courts altogether. So to that end, in July of this year, a mere month after the award was issued, the consortium commenced recognition and enforcement proceedings in the Southern District of New York. They did not wait to see whether there would be a set-aside application in Mexico. They did not wait for the set-aside period to expire. They just brought their application. And so what they're essentially doing is seeking enforcement of the award in the US, regardless of the judicial treatment of the award in the seat in Mexico. And it's through this application in the Southern District of New York that the Spanish and English translations of the award itself became public. They were Exhibit 1 to the application, as they typically would be. And for those of you interested, the parties are, again, pardon my pronunciation, Omega Construcciones Industriales and Sinhydro Costa Rica and Desarrollo y Construcciones Urbanas. And they're the petitioners, and the respondent was the Comisión Federal de Electricidad of Mexico, Southern District of New York, docket number 120CV05787. So that's available publicly for those of you who are interested in the arbitration award itself and in following the progress of this case through the Southern District of New York. Those of you familiar with some of the history of arbitration in Mexico will recall the 2016 Comisa case. It's in which a company sought and obtained enforcement of an arbitration award that it had in its favor against a Mexican state-owned enterprise, also in the Southern District of New York. In that case, when they sought enforcement, the award had actually already been set aside in Mexico, and the US courts elected to enforce it, even though it had been set aside. The last case I'm going to discuss is out of the United Arab Emirates. So as you're likely aware, the UAE has been at the forefront of developments in arbitration in the Middle East. It's been actively promoting itself as the arbitration hub for the Middle East. And part of that involved in 2018 enacting a new and modernized arbitration law for the UAE. When that law was enacted, the UAE also repealed the provisions of the Civil Code of Procedure applicable to arbitration, as well as any other provisions of the UAE law that were contrary to this new arbitration law. However, a recent decision of the UAE Court of Cassation in June of this year suggests that the UAE courts may still take a more restrictive approach to interpreting the arbitration law. And it also serves as a cautionary tale for arbitrators with respect to compliance with local technicalities when issuing awards to ensure that they're enforceable. So this case involved an application to challenge the validity of a Dubai International Arbitration Center award on the basis that it wasn't properly executed by the arbitrators and therefore was unenforceable. Now, the arbitration law requires that arbitration awards be signed by the arbitrators. That's the extent of what it says. And therefore it follows that if the award is not executed properly, the court can refuse to enforce it. However, in this case, the award being challenged was actually executed on the last page, as one would expect, by all of the three of the arbitrators who participated in the arbitration. So on its face, it appeared to comply with the new arbitration law. And indeed, the UAE Court of Appeal agreed that it was in compliance and dismissed the challenging party's application. So this was appealed to the Court of Cassation, which quite surprisingly to many people found that the award wasn't properly executed and wasn't enforceable. So what was the basis of this argument? Well, under the Civil Procedure Code that the arbitration law replaced, the equivalent provision, which also said all it required was that the arbitrators had to sign the award. It had been interpreted by the UAE courts as requiring the arbitrators to sign every page of the award containing their reasoning and decision, and failing that, the award would no longer be valid. So even though in this case that civil procedure law had been repealed, theoretically the case law interpreting it also was no longer applicable. The Court of Cassation found that because the wording was the same, it was going to apply that prior case law under the old Civil Procedure Code to the new arbitration law. And on that basis, it found that this award hadn't been executed properly, and it found it to be unenforceable. Now, all was not lost. What the Court of Cassation did was refer it back down to the Court of Appeal. And this, under a different provision of the arbitration law in the UAE, would have given the parties and the arbitrators time to correct the deficiency. So ultimately, the door was left open to correct the award. It wasn't fatal. And I guess the last thing to keep in mind is just the importance of complying with local requirements that may not always be completely known. Now, in this case, obviously, it's doubtful the arbitrators could have anticipated that the requirements under the old law and the case law under the old law would still apply. But it serves as a reminder of the importance of keeping these requirements in mind when finalizing an award. Thank you very much. Back to you, Christina.
Thanks so much, Romeo, for that panoramic overview of developments in both Latin America and the Middle East. That Brazilian decision in particular for me certainly leaves food for thought. I'm going to, without any pause, turn things over to our final speaker, Tim Robbins, who's going to be handling recent developments in Asia.
Thanks very much, Christina. Much like many of my co-panelists, it is a large jurisdiction with many countries. So I'm going to focus on two arbitration-related updates from Hong Kong and China, followed by two interesting cases from Singapore, one of which actually has a subsequent related Chinese court decision. So the first point I want to discuss is it's called the Hong Kong Mainland Interim Relief Arrangement. And just for giggles, I'll tell you the full name. It's Arrangement Concerning Mutual Assistance in Court-Ordered Interim Measures in Aid of Arbitral Proceedings by the Courts of the Mainland and the Hong Kong Special Administrative Region, which is quite a mouthful, hence why the arrangement for short. So this came into effect in October of last year, And under the arrangement vis-a-vis Hong Kong, any party to arbitral proceedings seated in Hong Kong and administered by a qualified arbitral institution may, prior to the issuance of an arbitral award, apply to a competent mainland Chinese court for interim measures relating to arbitration proceedings. And that has to be in accordance with the relevant laws and regulations on mainland China. So traditionally, there was very little support that one could get in mainland China in aid of foreign arbitral proceedings. However, this makes it clear that these interim measures now include the preservation of assets, evidence, and relate to conduct as well. Now, these applications can be made before or after the arbitration is commenced. If it is made before the arbitration is commenced, then you must start the arbitration within 30 days of the relief being granted. Now, by virtue of this arrangement, Hong Kong is the only arbitration venue outside of mainland China where parties can obtain such relief. The list of qualified arbitral institutions in Hong Kong that will enjoy this benefit include, of course, the Hong Kong International Arbitration Center, CTAC's Hong Kong branch, the ICC's Asia office, the Hong Kong Maritime Arbitration Group, the South China International Center Hong Kong branch as well. It does not apply notably to ad hoc matters. The HKIAC has confirmed that in the past year, it has had 28 applications that is known under the arrangement, all of them ex parte, from parties in ongoing HKIAC arbitrations. To their knowledge, asset preservation orders have been granted in at least 17 matters for the preservation of assets totaling approximately 1.3 billion USD, which is a substantial sum. So approximately 30% of the applications in HKIAC cases have been made from parties in mainland China, and 70% were made by foreign parties. Approximately 50% concern assets or evidence owned by mainland Chinese parties, and the other 50% concern assets on the mainland owned by foreign parties. Now, this potentially provides an advantage for Hong Kong when parties are looking to consider arbitration venues in Asia. As some of you may be aware, there have been some questions recently regarding the status and future of Hong Kong's its place as a main arbitral seat, a leading arbitral seat. So hopefully this arrangement and other factors in the future may have some selective advantages to counter those changes in perception. And that is where I will stop my discussion of anything even remotely political for what I hope are obvious reasons, as I am based in Hong Kong. My second point that I'd like to address involves foreign institutions administering arbitration seated in China. Now, historically, the courts in China have interpreted law there as forbidding foreign institutions from administering arbitration seated in China. It was quite clear based on practice and decisions that only designated Chinese institutions were valid under arbitration law. However, this appears to have been shifted under another accessibly named policy that's even longer than the last one, so I won't bore you with it, but it relates to the Shanghai Free Trade Zone. So the measures that are in this elaborate on previously issued operation rules governing the operation of the Shanghai Free Trade Zone. So since 2015, foreign arbitral institutions have been allowed to set up representative offices in the Shanghai Free Trade Zone. Currently, there are offices for the HKIAC, ICC, SIIC, and KCAB from Korea. However, to date, those offices have been purely more for promotional efforts and for support and arranging arbitration hearings rather than administering cases in the mainland. However, under the new administrative measures, it appears that foreign arbitration institutions can administer, quote, foreign-related arbitrations in the Shanghai Free Trade Zone. Now, this policy was issued late last year, and it wasn't very clear originally. It didn't really clarify whether arbitrations administered by foreign institutions would be considered as arbitrations seated in China. And it also didn't clarify whether awards rendered in such arbitrations would be considered foreign awards for the purposes of the New York Convention, or whether they would be what's called foreign-related awards rendered by Chinese institutions. However, I've received unofficial confirmation that indeed that these awards, when they are starting to be rendered, will be considered foreign awards under the New York Convention. Understandably, the caseload for arbitration in China is quite substantial. CTAC in 2019 administered 3,333 disputes. with a total of almost 18 billion USD in dispute. Of that, 617 were foreign cases, so nearly 20% of its caseload. The Beijing Arbitration Commission in 2019 had a huge 6,700 cases, although the majority of those were domestic in nature. It had 163 foreign cases, approximately 1 billion in dispute. So you can imagine foreign arbitral institutions or other international arbitration institutions would be quite interested in this. As a last minute update, literally I learned today that the State Council of China published this past week a policy paper on opening up services sector in Beijing. So some of the language in this is reminiscent of the original language in 2015 that expanded the operations in Shanghai Free Trade Zone, allowing them to set up representative offices to assist with logistics and so forth. So it doesn't appear clear yet whether there will be any movement towards allowing foreign institutions to administer arbitration seated in Beijing, but this seems to indicate a potential move towards that. And you'll note later on in my talk that the second case I address kind of relates to this and builds on it. So the first case in Singapore that I wanted to discuss is VXS versus VXT. It's actually, it's the first decision, strangely enough, on international arbitration rendered by the Singapore International Commercial Court, which, similar to the court in Paris that Sarah was describing, was a court set up in 2015 in Singapore to kind of offer a venue for international commercial disputes. So this dispute arose under a Thai law governed agreement between a Thai claimant and a Mauritius registered investment company as a respondent. The key issue in the dispute was whether the respondent was liable to indemnify the claimant for Thai taxes imposed following the claimant's acquisition of an interest in shares. Now, the arbitration clause provided that disputes shall be exclusively and definitively settled by arbitration pursuant to the rules of the Singapore International Arbitration Center by 3 arbitrators appointed according to the rules. It was not disputed in this case that the arbitration agreement was governed by Singapore law. Now, the claimant commenced SIAC proceedings in May of 2017. Further to the respondent's proposal, both parties agreed that the proceedings would be conducted in accordance with the expedited procedure rules under the 2016 version of the SIAC rules. However, claimant insisted that a 3-arbitrator tribunal should be appointed in accordance with the arbitration agreement rather than a sole arbitrator, which is provided for as the default under Rule 5.2 of the SIAC rules. However, the SIAC went forward and proceeded to appoint a sole arbitrator. Just over a year later, the sole arbitrator issued a final award in the respondent's favor. In late August of 2018, which is about 2 months after the issuance of the final award, the claimant initiated set-aside proceedings in a Thai court, which obviously was a bit of a tactical mistake. It was only on the 9th of November, about 5 months after the issuance of the final award, that the claimant brought an application in the High Court of Singapore, in the court of the seat of arbitration, to set aside the final award on multiple bases. First, constitution of a sole arbitrator tribunal violated the arbitration agreement. Secondly, the final award exceeded the scope of matters submitted to arbitration, breach of public policy, and time limit issues as well. So this case was transferred to the Singapore International Commercial Court. Anselmo Reyes, who's a very well-known arbitrator in Asia, sat as a single judge on the SICC bench. He declined to set aside the final award, holding that none of the grounds that the claimant raised were made out. He dealt fairly quickly with the excess of jurisdiction and public policy grounds, also dealt with the time bar issue, which was nothing groundbreaking, but the most interesting was the sole arbitrator ground. He rejected this argument for the following reasons. First, he said the 2016 SIAC rules were incorporated by reference into the arbitration agreement. Having contracted to conduct arbitration in accordance with those rules, the parties were taken to have accepted the expedited procedure as provided under the rules, including Rule 5.2b, which provides the case shall be referred to a sole arbitrator unless the president of the SIC determines otherwise. The language relating to the appointment of 3 arbitrators and the arbitration agreement, he said, was insufficiently explicit to constitute an agreement to deviate from that rule. And the rules clearly provide that the rules and procedures set forth in Rule 5.2 shall apply even in cases where the arbitration agreement contains contrary terms. And he found that it was irrelevant that this version of the rules, which came into effect in 2016, was when the expedited procedure was introduced, The fact that the parties agreement was entered into in 2012, he did not think was sufficient. I admit when the expedited procedure first came into play in 2016, and I saw that there was this power to override an express agreement of 3 arbitrators, and especially in agreements that were entered into before the rules were in place. However, at least vis-a-vis Singapore cases and supervision of the Singapore courts, that has been put to rest for now. Moving on to my final case, this is Daesung Industrial Gases versus Praxair, which is another Singapore case. So briefly, Daesung Industrial Gas and its Gwangju affiliate were parties to a takeout agreement that it entered into in 2012 with a Chinese affiliate of Praxair, which is now part of an Irish-based chemicals group, Linde. The contract contained the following portions for the arbitration agreement. First, the agreement shall be governed by the laws of the People's Republic of China. And secondly, after a small escalation clause, if such negotiations fail, it is agreed by both parties that such disputes shall be finally submitted to the Singapore International Arbitration Center for arbitration in Shanghai, which shall be conducted in accordance with its arbitration rules. So in 2016, Daesung and its affiliate filed a notice of arbitration with the SIC against Praxair. Praxair objected to the jurisdiction of the tribunal on the basis that Chinese law, as discussed earlier, prohibited a foreign arbitral institution from administering a case seated in mainland China. Now, a majority of the tribunal, which comprised of He Pengfong of Airsheds in Singapore and Hong Kong arbitrator Philip Yang, issued a decision in 2017 and found that the tribunal did have decision. The majority did so on the basis that it made no logical or commercial sense for the parties to have intentionally selected a law to govern the arbitration agreement that would render it invalid. Teresa Cheng, who coincidentally is now the Secretary for Justice of Hong Kong, at that time dissented, concluding that Chinese law governed the agreement and that under the law, the case was a domestic dispute and could not be administered by a foreign institution. Praxair appealed the decision of the majority of the tribunal to the Singapore High Court and to challenge that decision. In July 2019, the High Court of Singapore reached the same conclusion as the majority of the tribunal, although it did so on the basis that the express reference to SIC rules manifested the party's intent for Singapore to be the seat, and that the reference to Shanghai should be construed as a choice of hearing venue. That decision was also appealed. In a decision late last year, the Singapore Court of Appeal reversed the decision of the High Court. In doing so, it found that the seat of arbitration was Shanghai, and the implied choice of law governing the arbitration agreement was Chinese law. And it did so using framework provided in a Singapore precedent, which sounds like it's much more in line with what the English court cases Jessica was discussing earlier as opposed to the French approach. The first step in this test being, did the parties expressly choose the proper law of the arbitration agreement? As discussed in this case, they did not. The second limb is, did the parties make an implied choice of the proper law governing the arbitration agreement? And the starting point for the Court of Appeal is that there is a presumption that the law otherwise governing the contract should also apply to the arbitration agreement. In this case, PRC law governed the contract, and therefore the presumption is that would also govern the arbitration agreement. The Court of Appeal emphasized that this starting point could be displaced, which is what the High Court had done. However, the Court of Appeal looked at the language arbitration in Shanghai and citing a number of authorities which supported the proposition that that wording means the parties chose Shanghai to be the seat and not, as the tribunal found, merely as the venue of the arbitration. The Court of Appeal acknowledged that a natural reading of arbitration in Shanghai could be displaced by other indications. It was argued that there were drafts and prior negotiations and so forth, but the court did not allow any of that evidence to be admitted under the parole evidence rule. So the outcome of this basically was that the Court of Appeal found that the arbitration was seated in Shanghai, PRC law governed the arbitration agreement, and therefore in those circumstances, the Court of Appeal did not even look as to whether it had, the tribunal had jurisdiction, as it was not the proper supervisory court, and told the parties to go on their way. So following that ruling, the parties suspended the arbitration while Daesung then applied to a Shanghai court to confirm the arbitration clause's validity. And in a rather unexpected ruling, the Shanghai No. 1 Intermediate People's Court found that the arbitration agreement was valid, and it said it contained all the elements that are required under Chinese law. First, an expression of the party's intent to submit the matter to arbitration. Secondly, the scope of matters being referred to arbitration. And three, a designated arbitration commission. The court dismissed Praxair's objections that non-Chinese institutions were prohibited from conducting arbitration proceedings in mainland China. The court noted that there's actually no express statutory instrument that prohibits non-Chinese arbitral institutions from conducting arbitration proceedings in mainland China, and that such a position, they said, was against the prevailing trend in international arbitration. Interestingly, it went further and suggested that Chinese arbitration law lacked an international perspective at the time it was adopted and was not fully in line with international practice. It stated that the proper interpretation of what an arbitration commission is under the arbitration law is a matter that will have to be resolved by legislation. Now, taken altogether, this decision seems very much to indicate that it's possible that Chinese courts are committed to further alignment with international standards for arbitration practice, which is a very welcome and promising sign. Between this judgment and the other developments that were discussed earlier with the Shanghai Free Trade Zone and additionally Beijing, it would appear that hopefully in the not so far future, parties will be more comfortable using foreign arbitral institutions with a Chinese mainland seat. Although I'm not sure if we're quite confident enough yet, but hopefully that's to come soon. Thanks, Christina. That wraps up my brief tour of Asia.
Thank you, Tim. Very interesting times indeed, and I think many of us, if not all of us, will continue to watch the arbitration developments in the future as they occur in Hong Kong and China. That concludes our presentation portion of the panel. I want to once again thank all of my co-panelists. It's late for some of you. It's very, very late for one of you. But I'm sure your presentations have generated, will generate interesting discussions for some of our audience members. And I do hope that all of you co-panelists, those who have been watching, will be able to join us for what is the social component of this event. So I want to thank everyone very much, and I hope to see you soon, because through the magic of technology, I understand that this social component will be taking directly preceding this panel. Thanks very much.